this is Gray Hughes of Gray Hughes Investigates on YouTube. Please hit that like button, share, and subscribe. Today's video is regarding the motion for a Franks hearing, one of the 4 different motions, or multiple motions that were denied by the judge in the Idaho 4 case regarding Brian Kohberger. All right, so what we're going to do is, these documents are pretty long, so this one's just going to be in regards to things that Dylan Mortensen said that we find out in the Franks hearing request. So they put out a motion, and in the judge's reply, there's some new information that we hadn't heard before, or it puts things in better context. All right, so let's get started on it right now. All right, now here is a summary I put the PDF file into ChatGPT. Does a great job of summarizing a massive document, and here we go. So it says, the summary of court order on defendant's motion for Franks hearing. The state of Idaho has charged Brian Kohberger with 1 count of burglary and 4 counts of first-degree murder for the killing of Madison Mogen, Kaylee Goncalves, Ethan Chapin, and Xander Kernodle in Moscow, Idaho on November 13, 2022. The defense requested a Franks hearing, arguing that law enforcement intentionally or recklessly misrepresented or omitted several material facts in probable cause affidavit used to obtain 17 different search warrants. And really the argument is, had the prosecutors and investigators put in accurate information, the judge who signed the warrant wouldn't have if he had gotten that information. Therefore, we believe that these warrants were unjustly signed, and everything that was, the fruit from that tree should be eliminated. And that's what they want to have a hearing to see if they can try to convince the judge that that's true, but they didn't even make it to the hearing. Okay, because it was all denied. The state opposed the request, stating that the defendant failed to meet the substantial preliminary showing required. And then the court's ruling, the court denied the motion for a full Franks hearing, but did allow limited evidentiary arguments on the investigative genetic genealogy issue. And those are those hearings a couple weeks back where they were off camera and then they came back in later. We covered those on this channel. The court concluded that the omission of IgG information did not invalidate the search warrants. As to the other claims, the defendant failed to meet the Franks standard for proving material misrepresentations or omissions. Then legal standard for Franks hearing. A Franks hearing is warranted only if a defendant can make a substantial preliminary showing that 1. Law enforcement knowingly, intentionally, or recklessly included false statements or omitted material information in a search warrant affidavit. 2. The false statements or omissions were necessary to the probable cause finding for the search warrant. Key issues raised by the defense and court's analysis. Investigative genetic genealogy omission. The defense law enforcement omitted the use of IgG in identifying Kohberger, misleading the court. So that's the defense's assertion that law enforcement omitted the use of IgG in identifying Kohberger, misleading the court. And then in the court replied by saying the omission was not material, as including it would have only bolstered probable cause. And then number 2, collective use of Exhibit A in search warrant affidavits. So defense asserts a group drafted probable cause statement was improperly used by multiple officers. The court replied officers are allowed to rely on collective law enforcement knowledge. Number 3, eyewitness testimony, Dylan Mortensen's statements. The defense asserts that law enforcement omitted inconsistencies in witness Dylan Mortensen's statements. Then the court replied Dylan Mortensen's statements were consistent and her inability to identify Kohberger was not material. Number 4, suspect vehicle identification. The Defense asserts FBI initially believed the suspect vehicle was a 2011 to 2013 Hyundai Elantra, later expanded to 2011 to 2016. The court finds that no evidence of intentional or reckless misrepresentation. I don't even understand the argument. It's like, he thought, okay, 2011 to 2013. You know what? I think it could also be 2011 to 2016. I mean, what's wrong with doing that? It's just wild that that's even an issue. Number 5, cell phone data analysis. Defense. The probable cause affidavit misrepresented when Kohberger's phone stopped reporting. The court said the discrepancies were minor and not intentionally misleading. Couldn't agree more. It's just absolutely meaningless time frame. In fact, it actually helps it a little bit. Because for me, it seemed like there was too much time in between the time it left and it's showing up at 3:26 on Indian Hills Drive there. All right, number 7, dog barking and crime scene observations. The defense asserts the affidavit failed to disclose that the dog continued barking for 30 minutes after the suspect left. The court responded, these details were not material to probable cause. Yeah, and who cares? Dogs bark for all kinds of reasons. Maybe it was barking out of stress, knowing that its owner was killed or something like that. We don't know. Dogs just bark. So to sit there and go, ooh, because it was barking, they wouldn't assign the probable cause. It's almost ludicrous. The DNA on the knife sheath trumps everything, everybody. Final decision. The court denied Kohberger's motion for Frank's hearing. The ruling affirms that none of the alleged misrepresentations or omissions were sufficient to affect the probable cause. This decision ensures that all search warrant evidence remains admissible in trial. Significance of the ruling. The ruling is a major victory for the prosecution, allowing key digital, eyewitness, and forensic evidence to be used. It establishes that IGG is not required to be disclosed if independent probable cause exists. It upholds the reliability of law enforcement investigations in high-profile cases. So there you go. That is the actual finding summarized by ChatGPT, which I think does an amazing job of doing that. So you get the main points. Now we're going to go into some of the portions of this long document where Dylan Mortensen commented. Okay, so we're going to bring those out, and there's some interesting sort of nuggets of information that we were able to get from these screenshots. So here is one right here. In issues 3 and 10, defendant challenges the probable cause statement insofar as they set forth witness Dylan Mortensen's interview descriptions of things she heard and saw on the night of November 13, 2022. Defendant claims that law enforcement failed to inform the magistrate that Dylan Mortensen's accounts describing the suspect were variable, that she questioned her memory, and that she did not recognize defendant when provided with a photo of him after his arrest. Defendant also contends that law enforcement misrepresented statements made by Dylan Mortensen that would have demonstrated her unreliability. These allegedly false statements and omissions, according to defendant, were exculpatory and material. While defendant's challenge may be fodder for cross-examination, it is not the proper subject of a Frank's motion. Defendant's own proffer establishes that Dylan Mortensen's accounts were remarkably consistent throughout her multiple interviews with law enforcement, and further, the probable cause affidavits are very consistent with her accounts. Second, Dylan Mortensen's interview statements that her memories were fuzzy and dreamlike and may have been affected by being tired or under the influence of alcohol do not call into question her reliability to the extent Frank's would require disclosure. Finally, Dylan Mortensen's failure to recognize the photo of defendant is of no consequence given that the intruder she saw was masked. And these are statements that are actually made in the Exhibit A. The draft Exhibit A circulated by law enforcement included the following description of statements Dylan Mortensen made during her interviews with law enforcement. Dylan Mortensen made statements during interview that included the occupants of the King Road residence were at home at 2 a.m. and reportedly asleep by approximately 4 a.m. This is with the exception of Kernodle, who received a DoorDash order at the residence at approximately 4 a.m. So if it is right around 4, it's about 8 minutes before Kohberger parked his car. Dylan Mortensen stated she was awoken at approximately 4 a.m. by what she stated sounded like Goncalves playing with her dog in one of the upstairs bedrooms, which were located on the 3rd floor. A short time later, Dylan Mortensen said she heard who she thought was Goncalves say something to the effect of, "There's someone here." A review of forensic records associated with a download of Kernodle's cellular phone indicated she was likely awake and using the TikTok app at approximately 4:12 a.m. Dylan Mortensen stated she looked out of her bedroom but did not see anything when she heard the comment about someone being in the house. Dylan Mortensen stated she opened her door a second time when she heard what she thought was crying coming from Kernodle's room. Then said she heard a male voice say something to the effect of, "It's okay, I'm going to help you." At approximately 4:17 a.m., a camera at 1112 King Road picked up audio of what sounded like a struggle coming from off camera. The security camera is less than 50 feet from Kernodle's bedroom, the bedroom wall. The struggle lasted less than 1 minute, and unintelligible sounds can be heard on the camera. Dylan Mortensen stated she opened her door for the 3rd time after she heard the crying and saw a figure clad in black clothing and mask that cover the person's mouth and nose walking towards her. Dylan Mortensen described the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. The male walked past Dylan Mortensen as she stood in a frozen shock phase. As the male walked towards the backsliding glass door, Dylan Mortensen locked herself in a room after seeing the male. So if we were looking inside the house, let's just go back a little bit. So as we just come into the living room, right, to the right is the front parking lot outside the wall there. This is Xana Kernodle's room. Now see that window right there? That's the same window that we see right here. That's this window. And then this building here is 1112 King Road. And as you can see, if I go about right here, let's say, I'll just use that. So right there is, this right here is Xana Kernodle's wall. And right on this light here was a Ring camera. Now if we were looking at a map from above, I marked this earlier. If you can see right here, this is Xana Kernodle's room is right here, and then I have a measuring line going right to the side of the house here that has the camera on it, and it looks like it's about 52 to 53 feet. You know, they say it's less than 50 feet. Either way, it's really close. I mean, let's say it's 55 to 60 feet away. Very close. And so that's why you can hear the audio coming from Xana's room, because it's really close. Now, Madison Mogan, where her and Kaylee Goncalves were found, there's a bathroom that actually would muffle and block the sound from making its way outside and being able to hear it on the camera on that side. Had there been a camera on the side where Kohberger likely parked his car, maybe back over in this area, if there was a camera, you might be able to hear something. Now this camera over here, you know, if there was sound coming from there, it might have a chance of picking it up. But so far we haven't heard anything definitive coming from that camera over there. All right, so let's take a look at the next statements made by or segments related to Dylan Mortensen. Defendant next asserts that the probable cause statements omitted important information bearing on Dylan Mortensen's reliability. Defendant notes that Dylan Mortensen qualified her interview statements on several occasions by questioning her memory of the event. For example, she told Detective Mallory everything was kind of blurry, like, "I don't fully remember it," I would say. And it says that a few days later, while accounting the events to Detective Gooch, Dylan Mortensen stated, "Again, I believe I was also very drunk. I don't know how much of this is real. Like, I don't know if my mind was like doing whatever. I don't know any of it. Like, half this stuff, I don't know if it's a dream or if it's real. I just have no clue." She also said her memory was fuzzy and cloudy, and she could not differentiate if anything is real or anything is a dream. The information was not included in Exhibit A's, according to the defendant. This information was crucial to allow the magistrate to properly evaluate Dylan Mortensen's reliability, and its omission was material and exculpatory. The law does not favor defendant on this argument. Probable cause is determined by examining the totality of the circumstances and making practical common sense decision whether giving all the circumstances set forth in the affidavit before the court, including the veracity and basis of knowledge of persons supplying hearsay information, there is a fair probability that contraband or evidence of a crime will be found in a particular place. All right, so in this one, they're trying to get it tossed out that her memory isn't good, and I think what they're really trying to have tossed out is her saying that she saw the description of him being athletically built and the bushy eyebrows, and then that was consistent with the driver's licenses that law enforcement looked at to see, oh wow, this guy has bushy eyebrows also, and they want that thrown out because the bushy eyebrows is something that really was noticeable and is meaningful and would be at trial as well. All right, so let's take a look at the next segment regarding Dylan Mortensen. Defendant also contends that law enforcement failure to include Dylan Mortensen's non-recognition of defendant in Exhibit A's warrant a Franks hearing. During her December 30th, 2022 interview with law enforcement, Dylan Mortensen was shown a defendant's mugshot and asked by Detective Lake whether defendant was the person she saw in her house. Dylan Mortensen responded, "I have no clue. From what I remember, I just remember seeing his figure, seeing this figure that was more of like the skinnier tone build and some mask on. I don't know if it was covering his mouth, his nose, or below his mouth and nose. I just remember he was white, but I didn't know how he was white." I don't know what that means, how he was white. I just knew he was, and I knew he looked at me because of the bushy eyebrows. Right, so if we take a look in here, let's go. So this is Dylan Mortensen's room. This is the living room. Right there on the left is Dylan Mortensen's room, and he walked by like this. So he would have walked by like this and turned to the right, and apparently she was looking out this door here and saw him. And I don't know if he was looking right at her. I mean, that's interesting. If she believes he actually saw her and then left, she's incredibly lucky. However, the fact Dylan Mortensen could not identify defendant is hardly exculpatory or material to probable cause. So it's United States versus Coakley 899 F2D 297-302 4th Circuit 1990, holding that omission of non-identification from photo spread was not material and that the Fourth Amendment does not require an affiant to include all potentially exculpatory evidence in the affidavit. Her interview statements, I think it's probably supposed to say consistently described a black-clad masked person who was not someone she thought she knew or could identify. Her inability to recognize defendant unmasked is expected, particularly where her description as relayed in Exhibit A's describes a mask that covered the person's mouth and nose. Thus, because her non-recognition is not material and exculpatory, defendant cannot demonstrate the failure to include this fact in the probable cause affidavit warrants a Franks hearing. Defendant has not demonstrated law enforcement omitted it intentionally or recklessly, nor has she shown how including the information would have affected probable cause. One simply cannot say that law enforcement included a statement that Dylan Mortensen, unsurprisingly, was unable to recognize defendant from a photo. The magistrate would not have found probable cause. A Franks hearing is not warranted on this issue. Yeah, I mean, even the judge, you can see he's sort of being a little bit sarcastic there by saying, unsurprisingly. And again, it just shows you, when we were listening to Ann Taylor in court arguing these points, these are the same thoughts we were having. And it's just absolutely ludicrous logic. I know she's trying anything she can She's seeing if something will stick. She wants to make sure that she's done her due diligence and all that kind of stuff. But man, you'd think there'd be at least an attempt at arguing these issues better. All right, so let's take a look at the next one. Defendant has not met his Frank's burden on issue 9, footprint outside Dylan Mortensen's door. In issue 9, defendant challenges as false statement made in Payne Exhibit A about a footprint found outside Dylan Mortensen's door. During the processing of the crime scene, the investigators found a latent shoe print. The detected shoe print showed a diamond-shaped pattern similar to the pattern of a Vans-type shoe sole, just outside the door of Dylan Mortensen's bedroom located on the second floor. This is consistent with Dylan Mortensen's statement regarding suspect's path of travel. And on to the next portion. It says, defendant contends the last sentence is false, noting that the footprint is closer to her bedroom door than she reported the suspect to be. There are no other prints before or after it, and it is not positioned towards the sliding glass door, which is where Dylan Mortensen said the suspect walked after passing by her. Defendant further claims it is intentional or reckless statement because its only purpose was to corroborate Dylan Mortensen's unreliable statements. Okay, well, I mean, let's take a look at it from inside. So let's just back up slightly. That's Dylan Mortensen's room on the left. And I guarantee you the footprint is heading in that direction, towards the stairs. Had it been facing towards the kitchen, the defense would have nothing to say. If it was facing backwards, they would make a huge deal out of that because it's going completely opposite direction. But I think it's going that direction, and it's probably closer to the door. So he came out, walked this direction, and then turned to the right. And, you know, it's just absolutely grasping at straws by the defense here, because it's absolutely consistent to have a footprint facing the stairs if you are leaving out the kitchen, because let's go into Dylan's room and then look. So right down below here would be where a footprint would be, and then you would take a right and go into the kitchen and leave. All right, so there's absolutely nothing to that. It's just crazy, these arguments that were made. There is nothing false or misleading about Detective Payne's statement. The shoe print was consistent with Dylan Mortensen's account. She told law enforcement she saw defendant walked past her bedroom door after she opened it for a third time. And then I opened the door again, and the guy is right there. I think he was walking past my door like saw me, I would say. He was about 3 feet away from her. Dylan Mortensen's bedroom door is immediately at the landing at the base of the stairs leading to the upstairs bedroom. Now, there's a lot of pro-burgers out there that still don't know the layout of the house and get confused on issues like this. The shoe print was therefore reasonable within the suspect's path of travel as described by Dylan Mortensen. Further, the fact the footprint was located only in one spot and there were no others before and after it does not make Detective Payne's statement false about the path of travel. Consequently, defendant has not shown Detective Payne's statement was false or otherwise misleading. Additionally, defendant has not established that Dylan Mortensen's interview statements were wholly unreliable as discussed supra, or that there was otherwise a need to bolster her credibility in the magistrate's eyes through false corroborations. Consequently, even if the shoe print was not totally consistent with Dylan Mortensen's account, defendant has not demonstrated that the statement was made deliberately or recklessly. Moreover, defendant has not articulated how excision of the statement would have any bearing on probable cause. In fact, it would not. A Frank's hearing is not warranted on this issue. Yeah, and the thing is even if the footprint was going the other direction, maybe that would just allow law enforcement to theorize. All right, let's move on to the next segment. Here we go. Defendant also asserts that Exhibit A's a watered-down Dylan Mortensen statement about hearing Kaylee Goncalves around the time of the homicides. According to defendant, Dylan Mortensen was unequivocal in her 3 interviews where she reported that at approximately 4 a.m. she heard Miss Goncalves walk upstairs with her dog before running back down the stairs saying, "Someone's here." In Draft Exhibit A, however, law enforcement represented that Dylan Mortensen said she heard who she thought was Goncalves say something to the effect of, There's someone here. Defendant argues the addition of the word thought is false, and further, defendant surmises it was intentionally false to cover up the fact that Dylan Mortensen was wrong about what she heard. Defendant points out that Miss Goncalves was killed in the upstairs bedroom where she was found the next morning. Thus, it could not have been her who Dylan Mortensen heard running down the stairs at 4 a.m. Defendant contends that Dylan Mortensen's misperception, had it not been covered up by law enforcement, would have cast doubt on her reliability and therefore probable cause. However, the statement challenged by a defendant can be read in two ways. That Dylan Mortensen said, "I think it was Miss Goncalves," which is how defendant apparently reads it, and which he claims is inconsistent with Dylan Mortensen's interview statements. Or two, that Dylan Mortensen said she heard Miss Goncalves, but law enforcement had reason to think it could have been someone else. When the statement is reviewed in context, the latter makes more sense. In their respective Exhibit A's, Detective Payne and Sergeant Blaker immediately followed up the challenge statement with the following: a review of records obtained from a forensic download of Kernodle's phone showed this could also have been Kernodle, as her cellular phone indicated she was likely awake and using the TikTok app at approximately 4:12 a.m. Payne Exhibit A, Bates 5161, Blaker Exhibit A, and Bates 5200. Emphasis added through his explanation. Payne and Blaker are effectively conveying to the magistrate why they believe Dylan Mortensen's statement of who she heard was questionable. Thus, the court cannot conclude there is anything false or misleading in this regard. In addition, even assuming it was false statement, defendant has not established that it was an intentional or reckless attempt to hide Dylan Mortensen's alleged misperception, or that her actual statement was exculpatory or otherwise material to probable cause. Consequently, a Frank's hearing is not warranted with regards to statements in the relevant Exhibit A's regarding Dylan Mortensen's account of what she saw and heard. And the thing is Dylan Mortensen, other than the bushy eyebrow portion, isn't really, doesn't have massive input in that probable cause. I mean, sure, it's like, okay, I think you left through the sliding glass door. A killer did go into the house and it killed those people and likely left out the sliding glass door. And it's Brian Kohberger. His DNA was found on the knife sheath in Madison Mogen's room while a white Elantra with missing its front license plate was parked outside the residence for the 12-minute window that all four were killed, and that knife sheath was left on the bed. All right, let's move on to the next portion. Now, this portion mentions a vacuum-type object, which is kind of interesting. When these Exhibit A's were submitted in support of search warrant applications, Dylan Mortensen had sat for at least 3 interviews with law enforcement, 2 on November 13th, so 2 on the day the bodies were found and the day that they were killed, 1 with Officer Nunez and later with Detective Mowry, and 1 on November 17th, which is 4 days later, with Detective Gooch. Her description of the intruder was notably similar during all 3 interviews. Number 1, it was a white male. 2, slim, skinny, lean body type. 3, slightly taller than Dylan Mortensen, 5'10". 4, wearing all black. And 5, wearing a mask that was covering his forehead and mouth. A voice she didn't recognize, that's number 6, saying, "He was here to help." And 7, the intruder walked out or towards the back sliding door without saying anything to her. While she did not tell Officer Nunez that she noticed the intruder carrying a vacuum-type object in his hand, she did convey that information to Detective Mowry later that day, as well as Detective Gooch. A few days after that, she also told Detective Gooch that she remembered the suspect's eyebrows were bushy, but could not remember their color. Likewise, told Detective Mowry she could not remember the color of his eyebrows. It's sort of interesting, that vacuum-type object. Now, I'm not sure I buy it, but there's people out online that think that what they might be talking about, Dylan, is maybe an object like that, and a vacuum-like object. You know, maybe it was a knife, but it sort of, in her mind, she thought it looked like a vacuum object. I don't know. It sounds to me like maybe he's carrying something larger that we're not aware about. But it'd be interesting to hear her full description of that. And, you know, some people are saying it's this object right here. More importantly, not only are Dylan Mortensen's statements consistent with each other with regard to the intruder description, they were accurately included by law enforcement in Exhibit A set forth above. There is not one statement in the affidavit regarding the intruder that cannot be traced directly to Dylan Mortensen's words. Consequently, defendant has not demonstrated an intentional or reckless false statement or omission of material exculpatory fact with regard to law enforcement recounting of Dylan Mortensen's description of the suspect. Yeah, so again, it's just the illogic by Ann Taylor, you know, just fails her. Like when we were watching, we hear what she's saying, and it's just like, God, what are you talking about, man? It's unreal. It's unreal. All right, everybody. Hope you guys thought that was interesting. Ann Taylor and Kohberger got absolutely smoked in these rulings, and this one was just regarding a portion of the Frank's hearing decision. There isn't going to be a Frank's hearing. They had a limited sort of Frank's hearing on IGG. That was denied. Everything's been denied. And rightfully so, it should have all been denied. It's really kind of obvious in this case. So I hope you guys found it interesting. You know, we got a lot of details like how close Kohberger was, and now we know that Dylan thought he was even looking at her, Kohberger, and he was holding something that was sort of like a vacuum part or something, part of a vacuum, or like a piece that goes through a vacuum. Hard to really know what she was talking about. And then he goes out the sliding glass door. You know, now we know he's wearing like a balaclava. You know, the bushy eyebrows we've already known about. And now we know for certain, because Dylan Mortensen said that the voice who said, I'm here to help, wasn't Ethan Chapin. It was an unknown voice, and that is likely Brian Kohberger, since he's the killer. All right, everybody, thank you all very much for watching. Make sure to hit that like button, share, and subscribe. And as I always say, until next time, be safe out there.